Okay, so andito na naman ang inyong Lolo Ray para mag-discuss na naman, magbasa pala ng mga batas. Okay, nagtapos tayo nung unang-una kasi nagbabasa ako ng Civil Code. Ngayon napansin ko, nagsimula tayo dun sa Civil Code Book 1. So natapos na natin sa unang live ko yung basahin, yung Civil Personality, yung buong Title 1 and yung Title 2, Citizenship and Domicile. However, napansin ko doon sa Title 3, yung marriage, napalitan na yun eh. Title 3 hanggang hanggang Title 16 kasi ang Book 1 ng Civil Code. So, ang makapangyayari na doon, sa aking pagkakaalam, ay yung Family Code na. So, hindi ko nababasahin yung mga ibang luma na nakalagay sa Civil Code. Ang basahin na natin yung nakalagay sa Family Code. Okay, in relation pa rin to rin sa Book 1 na tungkol sa pamilya. Okay. So, ang Family Code po ay ang Executive Order number 209 signed on July 6, 1987 by the President of the Philippines. O, ito siya. Title 1. Marriage. Okay. So, dito tayo magsimula. Requisites of marriage. Sabi rito, Article 1 ng Chapter 1, marriage is a special contract of permanent union between a man and a woman entered into in accordance. It is the foundation of the family and an inviolable social institution whose nature, consequences, and incidents are governed by law and not relations during the marriage within the limits provided by this code. So, nakalagay pa rin ito dun sa lumang civil code. Pero siguro mas kompleto na at mas bago na. Ito na yung dapat nating basahin regarding sa mga task na may kinalaman sa pagpapamilya. No? Article 2, sabi rito, no marriage shall be valid unless these essential requisites are present. Number 1, legal capacity of the contracting parties who must be a male and a female. Number 2, consent freely given in the presence of the solemnizing officer. Okay. Dalawa na lang pala yung essential requisites. Okay. Yun yung essential, yun yung kailangan para sa isang valid marriage. Ngayon, ito naman yung mga formal na requisites. Article 3, sabi rito, the formal requisites of a marriage are, number 1, yung authority of the solemnizing officer. Number 2, a valid marriage license, except in the cases provided for in Chapter 2 of this title. And number 3, a marriage ceremony which takes place with the appearance of the contracting parties before the solemnizing officer and their personal declaration that they take each other as husband and wife in the presence of not less than 2 witnesses of legal age. Nakalagay yan sa 53 and 55A doon sa lumang civil code, no? Article 4, the absence of any of the essential or formal requisites shall render the marriage void ab initio, except as stated in Article 35. So, supplementary pa rin yung labor code palagi. So, ang malinaw yung nakalagay sa Article 4. The absence of any of the essential or formal requisites shall render the marriage void ab initio. Ibig sabihin, void from the beginning. So, ulitin nga natin. Sabi rito, requisites, essential requisites, legal capacity of the contracting parties who must be male and a female. At saka yung consent freely given. Ibig sabihin, hindi ka tinutukan ng shotgun para magpakasal in the presence of the solemnizing officer. Yung mga formal na requisites, kailangan may authority. Yung solemnizing officer, hindi pa pwedeng ikasal lamang kita, wala naman ako authority. Number 2, valid marriage license except dun sa mga cases na nabanggit ko dun sa una kong live wherein 5 years na yata na nagsasama as husband and wife pero wala lamang kasal, hindi na sila kailangan kumuha yata. Hindi ako sure na naman ng valid license, pero yun lang ang example ng cases provided for dun sa chapter 2. Mamaya babasahin naman natin yan. And yung number 3, a marriage ceremony. So mahalaga ang seremonya, kailangan may seremonya which takes place with the appearance of the contracting parties. Kailangan naroon yung mga partidong kinakasal before the solemnizing officer and their personal declaration that they take each other as husband and wife in the presence of not less than 2 witnesses of legal age. Okay? Ituloy natin yung Article 4. Sabi niya, a defect in any of the essential requisites shall not affect the validity of the marriage, but the party or parties responsible for the irregularity shall be civilly, criminally, and administrative liable. So kung may depekto raw doon sa essential requisites, kunwari may depekto ron sa consent, doon sa solemnizing officer, or may depekto doon sa legal capacity, hindi naman ibig sabihin nun, hindi na agad valid yung marriage mo. Pero pwedeng makasuhan ng kasong kriminal, sibil, or administratibo yung taong may kinalaman doon. Kunwari, nang kakasal siya, wala naman siyang authority. Di pwedeng kasuhan ito administratibo or kriminal kung meron mang batas na nagpaparusa, parang usurpation of authority yata yun. O kaya kasong sibil, magbabayad siya ng danyos. Article 5, sabi rito, Article 5, sabi rito, any male or female of the age of 18 years or upwards, not under any of the impediments mentioned in Articles 37 and 38, may contract marriage. So pupunta tayo mamaya. Article 6, no prescribed form or religious rite for the solemnization of the marriage is required. It shall be necessary, however, for the contracting parties to appear personally before the solemnizing officer and declare in the presence of not less than 2 witnesses of legal age that they take each other as husband and wife. Kaya siguro pag nakakanood tayo sa pelikula, sapat na yung minamandali nila na, do you take ganito? I do. Do you? Ikaw lalaki? I do. Ganon. This declaration shall be contained in the marriage certificate, which shall be signed by the contracting parties and their witnesses and attested by the solemnizing officer. Okay, so mapunta naman tayo. Doon muna. In case of a marriage in articulum mortis o yung at point of death, when the party at the point of death is unable to assign the marriage certificate, it shall be sufficient for one of the witnesses to the marriage to write the name of said party, which fact shall be attested by the solemnizing officer. So patototohanan din yun, no, solemnizing officer, na talagang kinasal siya at the point of death, hindi na siya makapirma, hindi na siya makasulat. Tungo tayo sa Article 7. Article 7, sinasabi rito, marriage may be solemnized by. Sino lamang ba may mga yung pwedeng magkasal? Number 1, any incumbent member of the judiciary within the court's jurisdiction. Number 2, any priest, rabbi, imam, or minister of any church or religious sect duly authorized. Teka lang hanap lang ako ng pwesto ko maganda. Medyo nangangalay ako Alam, baka tumumba na naman yung... Okay, ganito muna tayo. Sandali lang yan. Okay, nasa na tayo? Nawala na ako. Ito. Ulitin natin. Article 7 ng Family Code. Sabi niya, marriage may be solemnized by any incumbent member of the judiciary within the court's jurisdiction. Number 2, any priest, rabbi, imam, or minister of any church or religious sect duly authorized by his church or religious sect and registered with the Civil Registrar General, acting within the limits of the written authority granted by his church or religious sect, and provided that at least one of the contracting parties belongs to the solemnizing officer's church or dun sa mga partidong kinakasal, miyembro nung church or sect na yon. Number 3, any ship. Number 4, any military commander of a unit to which a chaplain is assigned in the absence of the latter during a military operation, likewise only in the cases mentioned in Article 32. Number 5, any consul general, consul or vice consul in the case provided in Article 10. Okay? Yung sinasabi yung article na yon, kung di ako nagkakamali, doon pa yun sa lumang civil code. Binabasa ko yung kanina doon sa unang live natin about sa civil code. Kaya lang napag-isip-isip ko, marami nang binago ang family code. So, basahin na lang natin yung family code para mas malinaw. Article 8. The marriage shall be solemnized publicly in the chambers of the judge or in open court, in the church, chapel, or temple, or in the office and the consul, or in the office of the consul general, consul or vice consul, as the case may be, and not elsewhere, except in cases of marriages contracted on the point of death or in remote places, in accordance with Article 29 of this code, or where both of the parties request the solemnizing officer in writing, in which case the marriage may be solemnized at the house or place designated by them in a sworn statement to that effect. Okay? Tungo na tayo sa Article 9 ng Family Code pa rin. Okay? Article 9. Ano ba ito? Bakit ba hindi komportable ito? Yan. Okay. Okay. Okay, Article 9. A marriage license shall be issued by the local civil registrar of the city or municipality where either contracting party habitually resides, except in marriages, where no license is required in accordance with Chapter 2 of this title. Tungo naman tayo sa Article 10. Marriages between Filipino citizens abroad may be solemnized by a consul general, consul, or vice consul of the Republic of the Philippines. The issuance of the marriage license and the duties of the local civil registrar and of the solemnizing officer with regard to the celebration of marriage shall be performed by said consular official. Ang example nito, kunwari, ikaw ay nasa Dubai. Tapos mayroon kang kasintahan. Gusto niya na magsama. Parehas kayo nagtatrabaho sa Dubai. Hindi kayo pwede magsama kasi yung batas doon, hindi pinapayagan na magsama yung hindi kasal. So, ang remedyo doon para makapagsama na kayo, para makatipid kayo ng pagbabayad ng bahay, kunwari, magtungo na kayo sa may, doon sa Office of the Consul General, Consul or Vice Consul of the Republic of the Philippines, para maikasal na kayo, mairehistro na kayo doon, in accordance pa rin syempre with the Philippine laws, yung kasal. Kasi pag kinasal ka sa Office of the Consul, Philippine laws ang mga siwa. Pero at least pwede mo nang iparecognize sa Dubai na kayo mag-asawa at pwede na kayong manirahan na magkasama. Okay, so yun po yung payo ko dun sa mga nagtatanong sa akin na nasa Dubai at gusto na nilang magsama ng boyfriend nila dun. Article 11, where a marriage license, bago ko ituloy ito, pero bago ang lahat, magtanong muna kayo sa isang lisensyadong abogado. Yun lagi ko sinasabi. Ako, payo ko lang yun, parang kwento ng isang kaibigan, pinayo. Pero para makasigurado, lagi kayo magtatanong sa isang lisensyadong abogado. At kumari, hindi po sa akin. Okay? Article 11. Where a marriage license is required, each of the contracting parties shall file separately a sworn application for such license with the proper local civil registrar with such which shall specify the following. So ito yung nakalagay. Number 1, full name of the contracting party. Number 2, place of birth. Number 3, age and date of birth. Number 4, civil status. Number 5, if previously married, how and when and where the previous marriage was dissolved or annulled. Number 6, present residence and citizenship. Number 7, degree of relationship of the contracting parties. Number 8, full name, residence, and citizenship of the father. Number 9, full name, residence, and citizenship of the mother. Number 10, full name, residence, and citizenship of the guardian or person having charge in case the contracting party has neither father nor mother and is under the age of 21 years. Applicants, their parents or guardians, shall not be required to exhibit their residence certificates in any formality in connection with the securing of the marriage license. Article 12. The local civil registrar, upon receiving such applications, shall require the presentation of the original birth certificates or, in default thereof, the baptismal certificates of the contracting parties or copies of such documents duly attested by the persons having custody of the originals. These certificates or certified copies of the documents by this article need not be sworn to and shall be exempt from the documentary stamp tax. The signature and official title of the person issuing the certificate shall be sufficient proof of its authenticity. If either of the contracting parties is unable to produce his birth or baptismal certificate or a certified copy of either because of the destruction or loss of the original, or if it is shown by an affidavit of such party or of any other person that the certificate has not yet been received, though the same has been required of the person having custody thereof at least 15 days prior to the date of the application, such party may furnish in lieu thereof his current residence certificate or an instrument drawn up and sworn to before the local civil registrar concerned or any public official authorized to administer oaths. Such instrument shall contain the sworn declaration of two witnesses of lawful age, setting forth the full name, residence, and citizenship of such contracting party and of his or her parents, if known, and the place and date of birth of such party. The nearest of kin of the contracting parties shall be preferred as witnesses or in their default persons of good reputation in the province or the locality. Nakalagay pa rin sa civil code ito. The presentation of birth or baptismal certificate shall not be required if the parents of the contracting parties appear personally before the local civil registrar concerned and swear to the correctness of the lawful age of said parties as stated in the application, or when the local civil registrar or when the local civil registrar shall, by merely looking at the applicants upon their personally appearing before him, be convinced that either or both of them have the required age. Haba, no? Haba ng mga provision. Article 13. In case either of the contracting parties has been previously married, the applicant shall be required to furnish instead of the birth or baptismal certificate required in the last preceding article, the death certificate of the deceased spouse or the judicial decree of the absolute divorce. Ayun, so kung ikaw dati ka nang kinasal, hindi na baptismal or birth certificate ang re-require sa'yo, kung di yung death certificate, kung namaya pa na yung dati mong asawa, or yung judicial decree of the absolute divorce. Yung mga nasa abroad, na gustong mag-divorce doon, tapos ikasal dito, kailangan yun para sa annulment ninyo, or the judicial decree of annulment kung nagpa-annul man kayo dito, or declaration of nullity of his or her previous marriage. Excuse me po. In case the death certificate cannot be secured, the party shall make an affidavit setting forth his circumstance and his or her actual civil status and the name and date of death of the deceased spouse. Article 14. In case either or both of the contracting parties, not having been emancipated by a previous marriage, are between the ages of 18 and 21, they shall, sabi ko na dun sa nakaraang live ko, ang binabasa pa natin Civil Code 16 and 14 Ito na yung mga pangyayari ngayon. Ito na yung tama. Ulitin natin, yung mga ikakasal are between the ages of 18 and 21. They shall, in addition to the requirements of the preceding articles, exhibit to the local civil registrar the consent to their marriage of their father, mother, surviving parent or guardian, or persons having legal charge of them in the ordered mention. So, susundin mo yung order na yun. Unahin mo syempre yung father, mother, surviving parent or guardian, kung wala yung father or mother, o yung persons having legal charge sa inyo. Such consent shall be manifested in writing by the interested party who personally appears before the proper local civil registrar or in the form of an affidavit made in the presence of two witnesses and attested before any official authorized by law to administer oaths. The personal manifestation shall be recorded in both applications for marriage license, and the affidavit, if one is executed, instead shall be attached to said applications. Article 15. Any contracting party between the age of 21 and 25, yung kanina, between 18 to 21. Ngayon naman, between the age of 21 and 25, shall be obliged to ask their parents or guardian for advice upon the intended marriage. So yung una, yung kanina, sa nagdaang binasa natin, kailangan kung ikakasal ka at ikaw ay between the age of 18 to 21, kailangan mo ng consent o pahintulot ng iyong mga magulang. Dito naman, sinasabi kung ikaw ay 21, sa pagitan ng edad na 21 hanggang 25, kailangan mo pa rin ng advice. Yun, kailangan mo makuha yung advice nila upon the intended marriage. If they not obtain such advice, or if it be unfavorable, the marriage license shall not be issued till after 3 months following the completion of the publication of the application therefore. A sworn statement by the contracting parties to the effect that such advice has been sought, together with the written advice given, if any, shall be attached to the application for marriage license. Should the parents or guardian refuse to give any advice, this fact shall be stated in the sworn statement. So manunumpa ka na hindi nagbigay ng advice ang iyong mga magulang. Article 16. In the cases where parental consent or parental advice is needed, the party or parties concerned shall, in addition to the requirements of the preceding articles, attach a certificate issued by a priest, imam, or minister authorized to solemnize marriage under Article 7 of this code, or a marriage counselor duly accredited by the proper government agency, to the effect that the contracting parties have undergone marriage counseling. At this point, I would just like to greet Mom's Ren's Kitchen. Hello. Hello. Failure to attach said certificates of marriage counseling shall suspend the issuance of the marriage license for a period of 3 months from the completion of the publication of the application. Issuance of the marriage license within the prohibited period shall subject the issuing officer to administrative sanctions but shall not affect the validity of the marriage. Should only one of the contracting parties need parental consent or parental advice, the other party must be present at the counseling referred to in the preceding paragraph. Article 17. The local civil registrar shall prepare a notice which shall contain the full names and residences of the applicants for a marriage license and other data given in the applications. The notice shall be posted for 10 consecutive days on a bulletin board outside the office of the local civil registrar, located in a conspicuous place within the building and accessible to the general public. Hello, Mom's Kitchen. Thank you for supporting. This notice shall request all persons having knowledge of any impediment to the marriage to advise the local civil registrar thereof. The marriage license shall be issued after the completion of the period of publication. Now let's go to Article 18. In case of any impediment o yung harang merong sagabal known to the local civil registrar or brought to his attention, he shall note down the particulars thereof and his findings thereon in the application for marriage license, but shall nonetheless issue said license after the completion of the period of publication, unless ordered otherwise by a competent court at his own instance or that of any interest party. No filing fee shall be charged for the petition, nor a corresponding bond required for the issuances of the order. Article 19. The local civil registrar shall require the payment of the fees prescribed by law or regulations before the issuance of the marriage license, period. No other sum shall be collected in the nature of a fee or tax of any kind for the issuance of said license. It shall, however, be issued free of charge to indigent parties, that is, those who have no visible means of income or whose income is insufficient for their subsistence, a fact established by their affidavit or by their oath before the local civil registrar. Article 20. The license shall be valid in any part of the Philippines for a period of 120 days from the date of from the date of issue and shall be deemed automatically cancelled at the expiration of the said period if the contracting parties have not made use of it. The expiry date shall be stamped in bold characters on the face of every license issued. Article 21. When either or both of the contracting parties are citizens of a foreign country, it shall be necessary for them before a marriage license can be obtained to submit a certificate of legal capacity to contract marriage issued by their respective diplomatic or consular officials. So yung mga dayuhan, foreigners na ikakasal dito, kailangan nilang mag-submit sa civil registrar ng certificate of legal capacity to contract marriage issued by their own diplomatic or consular officials. Stateless persons or refugees from other countries shall, in lieu of the certificate of legal capacity herein required, submit an affidavit stating the circumstances showing such capacity to contract marriage. Okay? Mga refugee, pwede pa rin namang ikasal. Gagawa lamang sila ng affidavit na nagsasabing sila ay refugee at hindi sila makakasecure ng kahit anong sertifikasyon mula sa kanilang bansa. Article 22. The marriage certificate in which the parties shall declare that they take each other as husband and wife shall also state. Ito yung nilalaman ng marriage certificate. Kanina marriage license yung pinag-usapan. Ito marriage certificate na mismo. Number 1, the full name, sex, and age of each contracting party. Number 2, their citizenship, religion, and habitual residence. Number 3, the date and precise time of the celebration of the marriage. Number 4, that a proper marriage license has been issued according to law except in marriage provided for in Chapter 2 of this title. Number 5, that either or both of the contracting parties have secured the parental consent in appropriate cases. Hello, Fatih Nador. Salam. Assalamualaikum. Number 6, that either or both of the contracting parties have complied with the legal requirement regarding parental advice in appropriate cases. Number 7, that the parties have entered into marriage settlement, if any, attaching a copy thereof. So, malinaw yan, ha? Full name, sex, age, citizenship, religion, habitual residence, date and precise time of celebration of marriage, the proper marriage license, parental consent kung kailangan, yung mga legal requirements, and the parties have entered into a marriage settlement kung meron man. Okay? Article 23, it shall be the duty of the person solemnizing the marriage to furnish either of the contracting parties the original of the marriage certificate referred to in Article 6 and to send the duplicate and triplicate copies of the certificate not later than 15 days after the marriage to the local civil registrar of the place where the marriage was solemnized. Proper receipts shall be issued by the local civil registrar to the solemnizing officer, transmitting copies of the marriage certificate. The solemnizing officer shall retain in his final the quadruplicate copy of the marriage certificate, the copy of the marriage certificate, the original of the marriage license, and in proper cases the affidavit of the contracting party regarding the solemnization of the marriage in place other than those mentioned in Article 8. So kailangan pala mag-secure ka ng affidavit kung ikaw ay ikakasal kunwari sa harap ng dagat o sa iba, kailangan magagawa ka ng affidavit kasi ang requirement is sa open court or sa munisipyo, ganyan, or sa simbahan. Article 24, it shall be the duty of the local civil registrar to prepare the documents required by this title and to administer oaths to all interested parties without any charge in both cases, walang bayad. The documents and affidavits filed in connection with applicants for marriage licenses shall be exempt from documentary stamp tax. Wala kang babayaran na documentary stamp tax. Article 25, the local civil registrar concerned shall enter all applications for marriage licenses filed with him in a registry book, strictly in the order in which the same are received. He shall record in said book the names of the applicants, the date on which the marriage license was issued, and such other data as may be necessary. Article 26. All marriages solemnized outside the Philippines in accordance with the laws in force in the country where they were solemnized and valid there as such shall also be valid in this country, except those prohibited under Articles 35 1, 4, 5, and 6, 3637, and uh, 38. Ayan ha. Where a marriage between a Filipino citizen and the foreigner is validly celebrated, and the divorce is thereafter validly obtained abroad by the alien spouse, capacitating him or her to remarry, the Filipino spouse shall have capacity to remarry under Philippine law. Okay? Sabi ron, yung kasal sa isang Pinoy at sa isang dayuhan, tapos nag-divorce na sila. Nakuha mo abroad yung divorce nila, papayagan na muling ikasal under the Philippine law yung Filipino citizen na yun. Chapter 2. Marriages exempted from license requirement. Ito basahin natin. Magsisimula ang Chapter 2 sa Article 27. In case either or both the contracting parties are at the point of death, Articulo Mortis, the marriage may be solemnized without necessity of a marriage license and shall remain valid even if the ailing party subsequently survives. So kahit na kunwari yung nasa punto ng kamatayan, nabuhay pa rin sila, valid pa rin yun kahit walang marriage license. Article 28, if the residence of either party is so located that there is no means of transportation to enable such party to appear personally before the local civil registrar, the marriage may be solemnized without necessity of a marriage license. Article 29. In the cases provided for in the two preceding articles, the solemnizing officer shall state in an affidavit executed before the local civil registrar or any other person legally authorized to administer oaths that the marriage was performed in articulo mortis, or that the resident of either party specifying the barrio or barangay is so located that there is no means of transportation to enable such party to appear personally before the local civil registrar, and that the officer took the necessary steps to ascertain the ages and relationship of the contracting parties and the absence of legal impediment to the marriage. Wala namang harang sa kanilang pagpapakasal. Walang legal na harang. Yun ang ibig sabihin ng legal impediment. Article 30. The original of the affidavit required in the last preceding article, yung nagdaang article na binasa natin, together with the legible, malinaw na copy of the marriage contract, shall be sent by the person solemnizing the marriage to the local civil registrar of the municipality where it was performed within the period of 30 days after the performance of the marriage. Article 31. A marriage in articulo mortis between passengers or crew members may also be solemnized by a ship captain or by an airplane pilot not only while the ship is at sea or the plane is in flight, but also during stopovers at ports of call. Article 32. A military commander of a unit who is commissioned officer shall likewise have authority to solemnize marriages in articulo mortis between persons within the zone of military operation, whether members of the armed forces or civilians. Article 33. Marriages among Muslim or among members of the ethnic cultural communities may be performed validly without the necessity of marriage license, provided they are solemnized in accordance with their customs, rights, or practices. So sa mga kapatid nating Muslim, maaari na silang ikasal kahit na wala silang marriage license, provided na yung kasal nila are solemnized in accordance o naaayon sa kanilang kultura, sa kanilang rights or practices, sa mga nakagawian nilang practice. Article 34. No license shall be necessary for the marriage of a man and a woman who have lived together as husband and wife for at least 5 years. O, ito yung sinasabi ko. And without any legal impediment to marry each other. Okay, linawin natin. Ang isang babae at ang isang lalaki na parehong walang legal impediment, ibig sabihin, Walang existing na kasal. Ibig sabihin, kung gugustuhin nila ikasal, pwede silang ikasal. At nagsasama na sila sa loob ng 5 taon as husband and wife, ay pwede nang ikasal ng walang marriage license. Okay? The contracting parties shall state the foregoing facts in an affidavit before any person authorized by law to administer oaths. The solemnizing officer shall also state under oath that he ascertained o sigurado siya sa qualifications of the contracting parties are found no legal impediment to the marriage. Ibang usapan po yung kunwari may dating asawa yung lalaki. Hindi pa sila annulled. Tapos may kinakasama na siyang ibang babae. 5 taon na sila nagsasama bilang mag-asawa. May legal impediment yun. Hindi pa rin sila pwedeng ikasal sapagkat hindi pa annulled yung kasal nung isa sa kanila. Okay, malinaw po yan ha. Tungo na tayo sa Chapter 3, Void and Voidable Marriages. Naku, marami ito. Article 35. The following marriages shall be void from the beginning. Okay? Magkaiba po yung void and voidable. Yung void, yun yung void from the beginning. Simula pa lang, wala nang bisa. Yung voidable, ipinawalang bisa. Pwedeng ipawalang bisa. Okay, number 1, ito yung mga void from the beginning. Number 1, those contracted by any party below 18 years of age, even with the consent of parents or guardians. Number 2, malinaw yun ha. Kahit may pahintulot pa mga magulang, kung below 18 years of age, yan ay void from the beginning. Walang bisa yan. Number 2, those solemnized by any person not legally authorized to perform marriages unless such marriages were contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so. So kung kunwari, meron dalawang nagmamahalan, nagpakasal sila sa akin, ayun, wala naman akong authority na magkasal. So yun ay void from the beginning. Unless daw, sa simula pa lamang naniniwala yung yung dalawang partido na kinakasal na ako, dun sa example natin, ay merong authority na magkasal. Pwedeng ma-cure yun. Pwedeng magamot yun. Pero yung alam nyo na walang authority, nagpakasal pa rin kayo, void yun from the beginning. Number 3, those solemnized without license except those covered under the preceding chapter. Number 4, those bigamous or polygamous marriages not falling under Article 41. O kunwari, isa kang Katoliko, kasal ka na, nagpakasal ka pa ulit, bigamous yun. Number 5, those contracted through mistake of one contracting party as to the identity of the other. Yung iba naman pala yung pinakasalan mo. Akala mo, sa yun, hindi pala. Kunwari, meron kang kamit, nagkakilala lang kayong textmate or magka-chat, nagkita kayo sa buong paniniwala mo, yung katagpo mo, yung ka-chat mong, kunwari, si Virginia Constyle yun. Tapos ang pinadala pala dito, yung kasambahay ni Virginia Constyle yun. Ang paniniwala mo siya si Virginia Constyle yun. That is void from the beginning. And number 6, those subsequent marriages that are void under Article 53. Okay? Article 36, a marriage contracted by any party who, at the time of the celebration, was psychologically incapacitated to comply with the essential marital obligations of marriage shall likewise be void, even if such incapacity becomes manifest only after its solemnization. So kunwari, hindi mo halata na may diferensya pala, psychologically incapacitated pala siyang ikasal. Nahalata mo lang na ikasal na kayo. Void from the beginning pa rin daw yun. Article 37, marriages between the following are incestuous and void, walang bisa from the beginning, whether relationship between the parties be legitimate or illegitimate. So number 1, ascendants and descendants of any degree. So yung pakasalan mo ang iyong lolo, tatay, kapatid, ay anak, bababa, yun ay incestuous at pinagbabawal ng batas. Walang bisa yun. Number 2, between brothers and sisters, whether full or half blood. Kahit pa half lang yan, bawal yan, incestuous yan. Article 38, ito naman yung marriages that shall be void from the beginning for reasons of public policy. Ito yung ang pangit pangit tignan. Number 1, between collateral blood relatives, whether legitimate or illegitimate up to the 4th civil degree. Kamag-anak mo, pinsan. Bawal yan. Within the 4th civil degree. Number 2, between step-parents and step-children. Di ba yung mga pornographic movies, nagpapalabas sila ng mga ganyan. Pero that is very disgusting and that is void from the beginning by reasons of public policy. Number 3, between parents-in-law and children-in-law. That is void from the beginning. Number 4, between the adopting parent and the adopted child. Kahit na maging 18 years old na yung adopted child, bawal pa rin yan by reason of public policy. Inadopt mo yung bata bilang anak mo, ituring mo siyang anak, hindi mo siya pwedeng ituring na asawa. Number 5, between the surviving spouse of the adopting parent and the adopted child. Number 6, between the surviving spouse of the adopted child and the adopter. Number 7, between an adopted child and a legitimate child of the adopter. Number 8, between adopted child of the same adopter. And number 9, between parties where one, with the intention to marry the other, killed that one person's spouse or kills his or her own spouse. Bawal yun. Pinatay mo yung asawa para ikaw ang ikasal. That is against public policy. And of course, there is a criminal sanction. No? Article 39. The action or defense for the declaration of absolute nullity of a marriage shall not prescribe. Okay. Open parenthesis, as amended by Executive Order 227 and Republic Act Number 8533, the phrase, however, in case of marriage celebrated before the effectivity of this code and falling under Article 36, such action or defense shall prescribe in 10 years after this code shall take in effect, has been deleted by RA 8533. Okay. Article 40. The absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. Okay. So yung kawalan ng bisa nung isang nagdaang kasal ay pwedeng i-invoke for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. Article 41. A marriage contracted by any person during subsistence of a previous marriage shall be null and void unless before the celebration of the subsequent marriage the prior spouse had been absent for 4 consecutive years and the spouse present has a well-founded belief that the absent spouse was already dead. Hindi naman pa pwede yung alam mo na nasa abroad lang yung asawa mo. 4 years ang kontrata niya doon, wala siya. Tapos maglalandi ka, sasabihin mo na tingin ko patay na yun. Hindi pwede yun. Isa kang malantong na tao nun. In case of disappearance, where there is danger of death under the circumstances set forth in the provisions of Article 391 of the Civil Code, an absence of only 2 years shall be sufficient. Ito naman yung mga may gera, sundalo siya, tapos nawala siya ng 2 taon. Yun, pwede na yun. Under Article 391 of the Civil Code. For the purpose of contracting the subsequent marriage under the preceding paragraph, the spouse present must institute a summary proceeding as provided in this code for the declaration of presumptive death of the absentee without prejudice to the effect of reappearance of the absent spouse. So, ang ibig sabihin lamang nun, magfa-file yung naiwang asawa ng presumptive death. Summary proceeding ang gagamitin na proceedings doon. Nabasa na natin yan without prejudice daw. Ibig sabihin, pag lumabas, nag-reappear yung asawa mo, turns out buhay pala siya, valid pa rin kayong mag-asawa. Article 42. The subsequent marriage referred to in the preceding article shall be automatically terminated by the recording of the affidavit of reappearance of the absent spouse. unless there is a judgment annulling the previous marriage or declaring it void ab initio. A sworn statement of the fact and circumstances of reappearance shall be recorded in the civil registry of the residence of the parties to the subsequent marriage at the instance of any interested person, with due notice to the spouses of the subsequent marriage and without prejudice to the fact of reappearance being judicially determined in case such fact is disputed. Doon naman tayo sa Article 43. The termination of the subsequent marriage referred to in the preceding article shall produce the following effects. So, ito yung magiging epekto pagka nag-grant ang iyong presumptive death. Ito yun, number 1. The children of the subsequent marriage conceived prior to the termination shall be considered legitimate. So, legitimate pa rin sila bago yung termination. Number 2, the absolute community of property or the conjugal partnership, as the case may be, shall be dissolved and liquidated. But if either spouse contracted said marriage in bad faith, his or her share of the net profits of the net profits of the community property or conjugal partnership's property shall be forfeited in favor of the common children, or if there are none, the children of the guilty spouse by a previous marriage, or in default of children, the innocent spouse. Number 3, donations by reason of marriage shall remain valid, except that if the donee contracted the marriage in bad faith, such donations made to said donee are revoked by operation of law. Number 4, the innocent spouse may revoke the designation of the other spouse who acted in bad faith as beneficiary in any insurance policy, even if such designation be stipulated as irrevocable. And number 5, so kahit pa irrevocable o hindi maaaring baguhin yung stipulation do sa insurance policy, the innocent spouse may revoke. Yun ang sabi nga rito. And number 5, the spouse who contracted the subsequent marriage in bad faith shall be disqualified to inherit from the innocent spouse by testate and intestate succession. So kung ikaw, nag-presumptive death ka doon sa asawa mo in bad faith, ikaw ay hindi na maaaring magmana pa sa kanya. Article 44. If both spouses of the subsequent marriage acted in bad faith, said marriage shall be void ab initio, and all donations by reason of marriage and testamentary dispositions made by one in favor of the other are revoked by operation of law. Okay? Article 45. A marriage may be annulled for any of the following causes existing at the time of the marriage. Iba naman to dun sa void from the beginning. Yung wala pa lang, wala nang bisa. Ito naman, voidable. Ito yung annulment. Okay, number 1. That the party in whose behalf it is sought to have the marriage annulled was 18 years of age or over, but below 21, and the marriage was solemnized without the consent of the parents, guardians, or person having substitute parental authority over the party. In that order yun unless after attaining the age of 21, such party freely cohabited with the other and both lived together as husband and wife. So kung kunwari, ikinasal kayo, above 18 years kayo of age pero below 21, wala kayong marriage consent na inyong parents, tapos hindi naman kayo nagsama as husband and wife, yan po ay pwedeng i-annul. Number 2, that either party was of unsound mind unless such party after coming to reason freely cohabited with the other as husband and wife. Pareho may unsound mind, pareho kunwaring depressed. O unless nga na lang daw matapos silang gumaling, patuloy pa rin silang freely cohabited. Nagsama pa rin sila ng patuloy as husband and wife. Number 3, that the consent of either party was obtained by fraud unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as husband and wife. Yan, fraud sila. Pero kung after naman daw ng lahat, they freely cohabited, hindi naman yan, okay pa rin yun. Number 4, that the consent of either party was obtained by force, intimidation, or undue influence unless the same having disappeared or ceased, such party thereafter freely cohabited with the other as husband and wife. So kung kunwari ako, nagpakasal lamang ako kay letter B dahil tinutukan ako ng baril ng tatay niya at umuwi ako sa kanila at patuloy akong tinututukan everyday at binabantaan ng tatay niya. Nung namatay na yung tatay niya, nakisama pa rin ako sa kanya. Okay pa rin yun. Okay. Pero kung nawala na yung tatay niya, nakipaghiwalay na ako, yun, pwedeng annulment yun. Number 5, that either party was physically incapable of consummating the marriage with the other and such incapacity continues and appears to be incurable. Kunwari, pareho kayong impotent, baog, or incurable, hindi na makukure pa, hindi na malulunasan pa ang inyong sakit. And number 6, that either party was afflicted with a sexually transmissible disease found to be serious and appears to be incurable. Pero mahalaga yung provision dito, sexually transmitted disease na serious and appears to be incurable. Kunwari, ang halimbawa niyan, AIDS, okay? HIV, yan. So kunwari, yung asawa mo nagkaroon ng ganon, pwede na kayong mag-annulment. Article 46, any of the following circumstances shall constitute fraud referring to in number 3 of the preceding article. Ito naman yung mga fraud para maging ground for annulment. Number 1, non-disclosure of a previous conviction by final judgment of the other party of a crime involving moral turpitude. Kunwari, hindi niya sinabi sa kanyang napangasawa na dati na pala siya na-convict sa crime of adultery. Yan. Number 2, concealment by the wife of the fact that at the time of the marriage, she was pregnant by a man other than her husband. So, nabuntis ka ng iba, pero nilihim mo, pilit mong pinapanagot doon sa mapapangasawa mo o sa napangasawa mo, nalaman. That is ground for annulment. Number 3, concealment of sexually transmissible disease regardless of its nature existing at the time of the marriage. Kunwari, itinago mo na ikaw ay may HIV. Ayan. Number 4, concealment of drug addiction, habitual alcoholism, or homosexuality, or lesbianism existing at the time of the marriage. So kung kunwari, itinago mo na ikaw ay bakla o tomboy o ikaw ay lasenggo o ikaw ay addict, tapos lumabas na ito sa kalagitnaan ng iyong kasal, that is a ground for annulment. No other misrepresentation or deceit as to character, health, rank, fortune, or chastity shall constitute such fraud as will give grounds for action for the annulment of marriage. So ito lang yung nakalagay na grounds. Pero kung kunwari, itinago ko, sabi ko, anak ako, mayaman ako, pero hindi pala, hindi yan kasali sa grounds, okay? Article 47, the action for annulment of marriage must be filed by the following persons and within the periods indicated therein. So number 1, for causes mentioned in number 1 of Article 45, by the party whose parent or guardian did not give his or her consent within 5 years after attaining the age of 21, or by the parent or guardian or person having legal charge of the minor at any time before such party has reached the age of 21. So yung mga magulang, pwede. Number 2, for causes mentioned in number 2 of Article 45, by the same spouse who had no knowledge, wala siyang kaalam-alam, of the other's insanity, or by any relative or guardian or person having legal charge of the insane at any time before the death of either party, or by the insane spouse during a lucid interval or after regaining sanity. So, yung insane spouse, pero merong period, yung lucid interval na nagiging matino siya. May asawa ako, hindi. Yun, pwede siyang mag-file ng annulment. Number 3, for causes mentioned in number 3 of Article 45, by the injured party within 5 years after the discovery of the fraud. So, malinaw dito, halos within 5 years lahat Dapat sa loob ng 5 years nung nalaman mo yung panloloko, yung fraud. Number 4, for cases mentioned in number 4 of Article 45, by the injured party, siya yung magpa-file nito. Within 5 years from the time the force, intimidation, or undue influence disappeared or ceased. So yung example ko rito, tinakot ako ng ama ni letter B. Pakasalan siya, pumayag ako dahil sa takot. Namatay na itong ama na ito. Wala nang other force or undue influence sa akin. Sa loob ng 5 taon, nung matapos mawala yung threat sa akin na yun, sa loob ng 5 taon, pwede na ako magpanal. Pero kung lumagpas na yung 5 taon na yun, wala na. Hindi ko na pwedeng gamitin yung ground na yun. Number 5, for causes mentioned in number 5 and 6 of Article 45, by the injured party within 5 years after the marriage. Okay? Tungo tayo sa Article 48. In all cases of annulment or declaration of absolute nullity of marriage, the court shall order the prosecuting attorney or fiscal assigned to it to appear on behalf of the state, to take steps to prevent collusion between the parties, and to take care that evidence is not fabricated or suppressed. In the cases referred to in the preceding paragraph, no judgment shall be based upon a stipulation of facts or confession of judgment. Article 49. During the pendency of the action and in the absence of adequate provisions in a written agreement between the spouses, the court shall provide for the support of the spouses in the custody and support of their common children. The court shall give paramount consideration to the moral and material welfare of said children and their choice of the parent with whom they wish to remain, as provided to in Title 9. Period. It shall also provide for appropriate visitation rights of the other parent. Okay? Sinasabi dito, during the pendency of the action. During the pendency of the annulment. Article 50. The effects provided for by paragraphs 2, 3, 4, and 5 of Article 43 and by Article 44 shall also apply in the proper cases to marriages which are declared ab initio o yung void from the beginning or annulled by final judgment under Articles 40 and 45. The final judgment in such cases shall provide for the liquidation, partition, and distribution of the properties of the spouses, the custody and support of the common children, and the delivery of third presumptive legitimes unless such matters had been adjudicated in previous judicial proceedings. All creditors of the spouses, as well as of the absolute community or the conjugal partnership, shall be notified of the proceedings for liquidation. In the partition, the conjugal dwelling and the lot on which it is situated shall be adjudicated in accordance with the provisions of Articles 102 and 129. Okay. Punta naman tayo sa Article 51. Yung pinasa natin, yun yung about annulment pa rin eh. Article 51, partition na ito. In said partition, the value of the presumptive legitimes of all common children, computed as of the date of the final judgment of the trial court, shall be delivered in cash, property, or sound securities unless the parties by mutual agreement judicially approved, judicially approved, had already provided for such matters. The children or their guardian or the trustee of their property may ask for the enforcement of the judgment. The delivery of the presumptive legitimes herein prescribed shall in no way prejudice the ultimate successional rights of the children accruing upon the death of either or both of the parents. But the value of the properties already received under the decree of annulment or absolute nullity shall be considered as advances on their legitime. Article 52. The judgment of annulment or of absolute nullity of the marriage, the partition and distribution of the properties of the spouses, and the delivery of the children's presumptive legitimes shall be recorded in the appropriate civil registry and registries of property. Otherwise, the same shall not affect third persons. So yung presumptive na mana ng mga bata shall be recorded in the appropriate civil registry. At kunwari, ari-arian yan, yung lote yan, Register of Deeds. Ganyan siguro yun. Article 53. Either of the former spouses may marry again after compliance with the requirements of the immediately preceding article. Otherwise, the subsequent marriage shall be null and void. So kung nakumpleto mo naman na yung yung requirements ng annulment at natapos na, nagdesisyon na yung korte, malaya ka na, naibigay mo na yung kailangan ng mga bata, pwede ka nang muling ikasal. Pero kung may kulang ka sa requirements, yung susunod mong kasal shall be null and void kasi hindi ka pa sumusunod sa requirements. Article 54. Children conceived or born before the judgment of annulment or absolute nullity of the marriage under Article 36 has become final and executory shall be considered legitimate. Period. Children conceived or born of the subsequent marriage under Article 53 shall likewise be legitimate. Okay? So, punta naman tayo sa Title 2. Pero bago yan, magpapahinga muna ako. Tapos susubukan kong basahin pa rin to. Marami-rami pa to. Tignan natin kung hanggang saan ako magtatapos. Diyan lang po kayo. Okay, so okay muli nagbabalik. Magtungo na tayo. Basahin natin lahat ng pwede nating basahin. Title 2 of the Family Code, yung legal separation. Okay. Article 55, a petition for legal separation may be filed on any of the following grounds. Number 1, repeated physical violence or grossly abusive conduct directed against the petitioner, a common child, or a child of the petitioner. Number 2, physical violence or moral pressure to compel the petitioner to change religious or political affiliation. Ako, bawal yan. Hindi mo pwedeng pilitin. Ground yan for legal separation. Number 3, the attempt of respondent to corrupt or induce the petitioner, a common child, or a child of the petitioner, to engage in prostitution or connivance in such corruption or inducement. Number 4, final judgment sentencing the respondent to imprisonment of more than 6 years, even if pardoned. Number 5, drug addiction or habitual alcoholism of the respondent. Number 6, lesbianism or homosexuality of the respondent. Number 7, contracting by the respondent of a subsequent bigamous marriage, whether in the Philippines or abroad. Number 8, sexual infidelity or perversion. Number 9, attempt by the respondent against the life of the petitioner Or number 10, abandonment of petitioner by respondent without justifiable cause for more than 1 year. Pero itong mga sinabi rito na ground for legal separation, may mas mabigat na rito. Sampahan mo ng kasong kriminal, 9262 na kaagad. For purposes, pero kasi itong ground na ito magagamit mo kapag ang may kasalanan ay yung babae. Diba? Kasi ito yung magiging protection naming mga lalaki. For purposes of this article, the term child shall include a child by nature or by adoption. Okay. Article 56. The petition for legal separation shall be denied on any of the following grounds. Number 1. Where the aggrieved party has condoned the offenses or act complained for. Number 2. Yung pinayagan mo naman, yung mga ginagawa niya, gusto mo rin, ginagawa mo rin. Number 2, when the aggrieved party has consented to the commission of the offense or act complained of. Number 3, where there is connivance between the parties in the commission of the offense or act constituting the ground for legal separation. May connivance pala kayo. Number 4, where both parties have given ground for legal separation. Number 5, where there is collusion between the parties to obtain decree of legal separation, di kaya pwedeng magkuntsabahan. And number 6, where the action is barred by prescription. Okay. Ibig sabihin, hindi na pinapayagan yung action na yan kasi matagal mo nang pinahintulutan na abusuhin ka. Okay, 90 to 62 ka na lang kung babae ka. Article 57. An action for legal separation shall be filed within 5 years from the time of the occurrence of the cause. So, within 5 years, yan sinasabing prescription. So, within 5 years na sinimulan gawin sa'yo yung mga nabanggit sa taas, yung nabanggit kanina, doon ka pwede mag-file ng legal separation. Pero kung lumagpas na, hindi na pwede. Yun yung barred by prescription na tinatawag. Article 58. An action for legal separation shall in no case be tried before 6 months shall have elapsed since the filing of the petition. Article 59. No legal separation may be decreed unless the court has taken steps toward the reconciliation of the spouses and is fully satisfied. Despite such efforts, that reconciliation is highly improbable. So, pagbabatiin muna kayo ng korte at pag nakita na ng korte na kahit na anong steps yung gawin para magkaayos sila, hindi pa rin, pwede nang ibigay yung legal separation. Article 60. No decree of legal separation shall be based upon stipulation of facts or a confession of judgment. In any case, the court shall order the prosecuting attorney or fiscal assigned to it to take steps to prevent collusion between the parties and to take care of that evidence and to take care that the evidence is not fabricated or suppressed. Hindi gawa-gawa wala mga ebidensya at hindi itinatago ang ebidensya. Article 61. After the filing of the petition for legal separation, the spouses shall be entitled to live separately from each other. The court, in the absence of a written agreement between the spouses, shall designate either of them or a third person to administer the absolute community or conjugal partnership property. The administrator appointed by the court shall have the same powers and duties as those of a guardian under the rules of court. Ayan. Basa natin yun sa rules of court. Article 62. During the pendency of the action for legal separation, the provisions of Article 49 shall likewise apply to the support of the spouses and the custody and support of the common children. Okay. So, yung 49, kanina, yung kung di ako nagkakamali, yung pendency, during the pendency ng annulment, ganon din sa legal separation during the pendency, yung proseso na yun ay siya mangungusap regarding the support of the spouses and the custody and support of the common children. Article 63. The decree of legal separation shall have the following effects. Ito yung epekto niya. Number 1, the spouses shall be entitled to live separately from each other, but the marriage bonds shall not be severed. So, kasal pa rin kayo. You're just entitled na manirahan separately from each other. Number 2, the absolute community or the conjugal partnership shall be dissolved and liquidated, but the offending spouse shall have no right to any share of the net profits earned by the absolute community or the conjugal partnership which shall be forfeited in accordance with the provisions of Article 43, number 2. So, madidissolve yung inyong absolute community. Pero yung nagkasalang asawa, hindi siya entitled sa kung ano mang kinikita ng inyong absolute community. Yung mga ari-arian ninyo na pinagsama-sama nung kayo ikinasal. Number 3, the custody of the minor children shall be awarded to the innocent spouse subject to the provisions of Article 213 of this code. So, syempre, yung innocenteng spouse sa kanya mga bata. Number 4, the offending spouse shall be disqualified from inheriting from the innocent spouse by intestate succession. Moreover, provisions in favor of the offending spouse made in the will of the innocent spouse shall be revoked by operation of law. So, hindi ka na kailanman maaaring magmana sa iyong asawa. Yun ang epekto nun. Pero, sabi nga dun sa number 1, the marriage bond shall not be severed. Ito lang mga nabanggit natin yung magiging epekto. Article 64. After the finality of the decree of legal separation, the innocent spouse may revoke the donations made by him or by her in favor of the offending spouse, as well as the designation of the latter as beneficiary in any insurance policy, even if such designation be stipulated as irrevocable. So, pwede mo na siyang alisin, yung nagkasalang spouse, as yung respondent sa iyong legal separation case laban sa kanya, hindi na siya pwedeng maging insurance beneficiary mo. The revocation of the donations shall be recorded in the registries of property in the places where the properties are located. So, kunwari may nag-donate ng ari-arian sa inyo bilang mag-asawa, bahagi yon ng inyong absolute community na sinasabi. Yung donasyon na yun will be revocated. Wala nang bisa yun. Babalik na doon sa nag-donate. Yung pag-aari nun. Alienations, liens, and encumbrances registered in good faith before the recording of the complaint for revocation in the registries of property shall be respected. The revocation of or change in the designation of the insurance beneficiary shall take effect upon written notification thereof to the insured. Tungo na tayo sa... wala pa pala. Di pa tapos. The action to revoke the donation under this article must be brought within 5 years from the time the decree of legal separation become final. So, dito puro 5 years ang sinasabi niya. Pag nag-grant iyong legal separation, legally separated na kayo, doon sa period ng 5 years, doon mo pwedeng iba yung action to revoke donation. Article 65, if the spouses should reconcile, a corresponding joint manifestation under oath duly signed by them shall be filed with the court in the same proceeding of the legal separation. So, pwede naman palang magkabati. O, ito naman yung Article 66, yung pagbabati naman. The reconciliation referred to in the preceding article shall have the following consequences. Ito naman yung consequences ng pagbabati. Number 1, the legal separation proceedings is if still pending, wala pang desisyon, shall thereby be terminated at whatever stage. Okay. And number 2, the final decree of legal separation shall be set aside, but the separation of property and any forfeiture of the share of the guilty spouse already affected shall subsist, mananatili, unless the spouses agree to revive their former property regime. Unless nagkasundo kayo muli, i-revive yung inyong common na pag-aari. The court's order containing the foregoing shall be recorded in the proper civil registries. Article 67. Pero kung ako, hindi ako naniniwala dito sa legal separation na ito. Kung binubugbog ka, kasuhan mo na agad ng 9262. Kung yung babae binubugbog, 9262 agad. Tapos pagka naman niloloko ka, di ba? 9262 plus annulment agad, ganun. Ibalay na kayo. Pero legal separation, remedyo ito ng mga lalaki. Kasi wala naman kaming anti-vowsy law eh. Remedyo namin itong mga lalaki sa nakikita ko para sa mga babae nagloloko. Article 67. The agreement to revive the former property regime referred to in the preceding article shall be executed under oath and shall specify, number 1, the properties to be contributed anew to the restored regime. Number 2, those to be retained as separated properties of each spouse. And number 3, the names of all their known creditors their addresses, and the amounts owing to each. Okay, yan yung epekto nung nagkabalikan na kayo. Na-terminate na yung or na-set aside na yung decision for legal separation. The agreement of revival and the motion for its approval shall be filed with the court in the same proceeding for legal separation, with copies of both furnished to the creditors named therein. After due hearing, the court shall, in its order, take measure to protect the interest of creditors, and such order shall be recorded in the proper registries of properties. The recording of the ordering in the registries of property shall not prejudice any creditor not listed or not notified unless the debtor spouse has sufficient separate properties to satisfy the creditor's claim. Okay? Magtungo naman tayo. Maikli na lamang to. Title 3. Rights and obligations between husband and wife. Article 68. The husband and wife are obliged to live together, observe mutual love, respect, and fidelity, and render mutual help and support. Article 69. The husband and wife shall fix the family domicile. In case of disagreement, the court shall decide. The court may exempt one spouse from living with the other if the latter should live abroad, or there are other valid and compelling reasons for the exemption. However, such exemption shall not apply if the same is not compatible with the solidarity of the family. Pwede lang kayong payagan ng korte na magkahiwalay manirahan kung ito ay alinsunod pa rin sa solidarity ng isang pamilya. Article 70. The spouses are jointly responsible for the support of the family. So yung mga babaeng pabebe, huwag kayong pabebe kasi responsable rin kayo sa pagpo-provide para sa pamilya. The expenses for such support and other conjugal obligations shall be paid from the community property, and in the absence thereof, from the income or fruits of their separate properties. In case of insufficiency or absence of said income or fruits, such obligations shall be satisfied from the separate properties. Article 71. The management of the household shall be the right and the duty of both spouses. The expenses for such management shall be paid in accordance with the provisions of Article 70. Article 72. When one of the spouses neglects his or her duties to the conjugal union or commits acts which tend to bring danger, dishonor, or injury to the other or to the family, the aggrieved party may apply to the court for relief. Ibig sabihin, may remedyo yan. Pwede kang magkasampa ng kaso sa asawa mong pasaway sa korte. Article 73. Either spouse may exercise any legitimate profession. Ang keyword dun is legitimate, lehitimong profesyon, occupation, business, or activity without the consent of the other. The latter may object only on valid, serious, and moral grounds. Okay? Kung kunwari gusto niya maging professional porn star, yun, bawal yun, siyempre. In case of disagreement, the court shall decide whether or not, number 1, the objection is proper, and number 2, the benefit has accrued to the family prior to the objection or thereafter, period. If the benefit accrued prior to the objection, the resulting obligation shall be enforced against the community property. If the benefit accrued thereafter, such obligation shall be enforced against the separate property of the spouse who has not obtained consent. The foregoing provisions shall not prejudice the rights of creditors who acted in good faith. Okay? Okay, mahaba pa yung property relations ng husband and wife. Title 4. Okay. Ba't di natin basahin na rin? Di ba? Basahin na rin natin. Title 4. Property relations between husband and wife. Chapter 1. General provisions. Nagsisimula ang Title 4 sa Article 74. The property relationship between husband and wife shall be governed in the following order. Number 1, by marriage settlements executed before the marriage. Ito yung prenup na alam natin. Number 2, by the provisions of this code. And number 3, by the local custom. Article 75. The future spouses may, in the marriage settlements, agree upon the regime of absolute community, conjugal partnership of gains, complete separation of property, or any other regime. In the absence of a marriage settlement, or when the regime agreed upon is void, the system of absolute community of property as established in this code shall govern. Article 76. In order that any modification in the marriage settlements may be valid, it must be made before the celebration of the marriage, subject to the provisions of Articles 66, 67, 128, 135, and 136. Article 77. The marriage settlements and any modification thereof shall be in writing, signed by the parties, and executed before the celebration of the marriage. They shall not prejudice third persons unless they are registered in the local civil registry where the marriage contract is recorded, as well as in the proper registries of properties. Article 78. A minor who according to law may contract marriage may also execute his or her marriage settlements, but they shall be valid only if the persons designated in Article 14 to give consent to the marriage are made parties to the agreement subject to the provisions of Title 9 of this code. Article 79. For the validity of any marriage settlement executed by a person upon whom a sentence of civil interdiction has been pronounced, or who is subject to any other disability, it shall be indispensable for the guardian appointed by a competent court to be made a party thereto. Article 80. In the absence of a contrary stipulation in a marriage settlement, the property relations of the spouses shall be governed by Philippine laws, regardless of the place of the celebration of the marriage and their residence. This rule shall not apply number of spouses are against. Syempre, dayuhan sila, so hindi apply yung sa kanila. Number two, with respect to the extrinsic validity of contracts affecting property not situated in the Philippines and executed in the country where the property is located. Sa ibang bansa, in-execute ang kontrata at yung kontrata ay patungkol sa property na nasa ibang bansa. And number three, with respect to the extrinsic validity of contracts entered into the Philippines but affecting property situated in a foreign country whose laws require different formalities for its extrinsic validity. Article 81. Everything stipulated in the settlements or contracts referred to in the preceding articles in consideration of a future marriage, including donations between the prospective spouses made therein, shall be rendered void if the marriage does not take place. However, stipulations that do not depend upon the celebration of marriages shall be valid. Okay. Chapter 2, Donations by Reason of Marriage. Magsisimula ang Chapter 2 sa Article 82. Donations by reason of marriage are those which are made before its celebration in consideration of the same and in favor of one or both of the future spouses. Ito yung mga donasyon sa kasal. Article 83, these donations are governed by the rules on ordinary donations established in Title 3 of Book 3 of the Civil Code insofar as they are not modified by the following articles. Okay. Article 84. If the future spouses agree upon a regime other than the absolute community of property, they cannot donate to each other in their marriage settlements more than 1/5 of their present property. Any excess shall be considered void. Donations of future property shall be governed by the provisions on testamentary succession and the formalities of wills. Okay? Article 85. Donations by reason of marriage of property subject to encumbrances shall be valid. Okay? In case of foreclosure of the encumbrance and the property is sold for less than the total amount of the obligation secured, the donee shall not be liable for the deficiency. If the property is sold for more than the total amount of said obligation, the donee shall be entitled to the excess. Article 86. A donation by reason of marriage may be revoked by the donor in the following cases. So dito mo lang pwedeng ipawalang bisa yung donasyon sa isang kasal. Number 1, if the marriage is not celebrated or judicially declared void ab initio, except donations made in marriage settlements which shall be governed by Article 81. So yung mga pagka na-declared void ab initio, void from the beginning, pwede. Maliban na lamang daw sa mga donasyon na ginawa in marriage settlements. Ang mga ngasiwa doon ay ang Article 81. Number 2, when the marriage takes place without the consent of the parents or guardian as required by law. Ayan, yung mga between 18 to 21. Number 3, when the marriage is annulled and the donee acted in bad faith. Yung pinagbigyan ng donasyon, acted in bad faith dun sa annulment. Number 4, upon legal separation and the donee being the guilty spouse. Siya ay nagkasala. Yung pinagbigyan, siya ay nagkasala. Number 5, if it is with a resolutory condition and the condition is complied with. Resolutory condition, ibig sabihin merong kondisyon. Tapos nangyari na yung kondisyon na yun. Number 6, when the donee has committed an act of ingratitude. Ingrato siya. As specified by the provisions of Civil Code on donations in general. Binigyan mo na, hindi pa magpasalamat, ingrato pa. Article 87. Every donation or grant of gratuitous advantage, direct or indirect, between the spouses during the marriage shall be void, except moderate gifts which the spouses may give each other on the occasion of any family rejoicing. The prohibition shall also apply to persons living together as husband and wife without a valid marriage. Okay? Haba pa. Asan na ako? Nawala na ako. Ayun. Chapter 3. System of Absolute Community. Section 1, General Provisions. Magsisimula ang Chapter 3 sa Article 88. The absolute community of property between spouses shall commence at the precise moment that the marriage is celebrated. Any stipulation expressed or implied for the commencement of the community regime at any other time shall be void. Lino yun, ha? Nasisimula yan at the moment the marriage is celebrated. Iisa na kayo. Pati ang inyong ari-arian, iisa na. Sakaling walang prenup. Yun na ibig sabihin nun. Article 89, no waiver of rights, shares, and effects of the absolute community of property during the marriage can be made except in case of judicial separation of property. When the waiver takes place upon a judicial separation of property or after the marriage has been dissolved or annulled, the same shall appear in a public instrument and shall be recorded as provided in Article 77. The creditors of the spouse who made such waiver may petition the court to rescind the waiver to the extent of the amount sufficient to cover the amount of their credits. Article 90. The provisions on co-ownership shall apply to the absolute community of property between the spouses in all matters not provided for in this chapter. Section 2. What constitutes community property? Article 91. Unless otherwise provided in this chapter or in the marriage settlements, the community property shall consist of all property owned by the spouses at the time of the celebration of the marriage or acquired thereafter. Okay. Article 92, the following shall be excluded from the community property. Ito yung hindi kasali sa community property ng mag-asawa. Mahalaga to. Number 1, property acquired during the marriage by gratuitous title by either spouse and the fruits as well as the income thereof, if any, unless it is expressly provided by the donor, testator, or grantor that they shall form part of the community of property. Basta hindi naman sinabi, binigay lamang sa isa sa inyo, gratuitously, hindi yun kasama. Okay? Kunwari, may tsuhin ka, binigyan ka ng lupa, sa'yo na yan. Yung isa sa mga spouses, hindi yun kasama sa absolute community. Unless sinabi niya na dinodonate ko to bilang bahagi ng absolute community ninyong mag-asawa. Number 2, property for personal and exclusive use of either spouse. However, jewelry shall form part of the community of property. Uy, yung mga alahas pala ng mga babae, kasali pala yan sa community property. Ha? Yung mga babae. Number 3, Property acquired before the marriage by either spouse who has legitimate descendants by a former marriage, and the fruits as well as the income, if any, of such property. So yung nakuha, yung minana ng isang spouse doon sa dati niyang asawa, kung meron siyang dating asawa, ah, or minana niya, ay hindi kasali sa community of property. Article 93, property acquired during the marriage is presumed to belong to the community unless it is proved that it is one of those excluded therefrom. Magtungo tayo sa Section 3. Ayos ba? Charges and obligations of the absolute community. Article 94, magsisimula ang Section 3. The absolute community of property shall be liable for, ito yung mga dapat niyong bayaran. Number 1, the support of the spouses, their common children, and legitimate children of either spouse. However, the support of illegitimate children shall be governed by the provisions of this code on support. Okay, so pagka illegitimate children, kailangan nating basahin yung provision on support. Number 2, all debts and obligations contracted during the marriage by the designated administrator spouse for the benefit of the community, or by both spouses, or by one spouse with the consent of the other. Number 3, debts and obligations contracted by either spouse without the consent of the other, to the extent that the family may have been benefited. Number 4, all taxes, liens, charges, and expenses including major or minor repairs upon the community property. Gagastusan nyo yan ng community property. Number 5, all taxes and expenses for mere preservation made during marriage upon the separate property of either spouse used by family. Kahit pag-aari pa yan ng either spouse, kung ginagamit nyo naman pampamilya, community of property ang gagastos dyan. Community, yung community, yung ano ninyo, yung pag-aari ninyong magkasama, ang gagastos dyan. Absolute community ninyo. Number 6, expenses to enable either spouse to commence or complete a professional or vocational course or other activity for self-improvement. Aba, absolute community rin pala ang mga ngasiwa dyan. Kung gusto mag-aral, pwede. Number 7, anti-nuptial debts of either spouse insofar as they have redounded to the benefit of the family. Okay? Anti-nuptial yung mga post-nuptial, pagkatapos ng kasal, na inutang ninyo, na nakinabang ang pamilya nyo, kailangan yung bayaran yan. Number 8, the value of what is donated or promised by both spouses in favor of their common legitimate children for the exclusive purpose of commencing or completing a professional or vocational course or other activity for self-improvement. Number 9, anti-nuptial debts of either spouse other than those falling under paragraph 7 of this article, the support of illegitimate children, diyan kasama, of either spouse, illegitimate children of either spouse, and liabilities incurred by either spouse by reason of a crime or a quasi-delict in case of absence or insufficiency of the exclusive property of the debtor spouse, the payment of which shall be considered as advances to be deducted from the share of the debtor spouse upon liquidation of the community. And number 10, expenses of litigation between the spouses unless the suit is found to be groundless. If the community property is insufficient to cover the foregoing liabilities except those falling under paragraph 9, the spouses shall be solidarily liable for the unpaid balance with their separate properties. Article 95, whatever may be lost during the marriage in any game of chance, betting, sweepstakes, or any other kind of gambling, whether permitted or prohibited by law, shall be borne by the loser and shall not be charged to the community, but any winnings therefrom shall form part of the community property. So mag-asawa kayo, under kayo ng absolute community, natalo ka sa sugal, hindi mo pwedeng ipa-shoulder yun sa absolute community ninyong dalawa, sapagkat kawawa naman ng pamilya, pero yung mapapanalunan mo ay kailangan kasama sa absolute community ng pamilya. Ang logic po noon, meron ka ng pamilya kapakanan ng pamilya ang dapat inuuna, pero yung makakasama sa kanila, hindi dapat dinadamay yung absolute community na para sa gastos ng pamilya, lalong-lalo na ng mga bata. Tandaan niyo po yan, ha, makakatulong yon. Section 4, ownership administrative. Ownership, administrative. Administrative. Enjoyment and disposition of the community property. Article 96. Ito yan. The administration and enjoyment of the community property shall belong to both spouses jointly. In case of disagreement, the husband's decision shall prevail, subject to recourse to the court by the wife for proper remedy, which must be availed of within 5 years from the date of the contract implementing such decision. So, ang mananalo rito, ang masusunod yung lalaki. Pero kung sa tingin ng asawa, hindi maayos yung desisyon ng lalaki, pwede siya magtungo sa korte para sa remedyo. In the event that one spouse is incapacitated or otherwise unable to participate in the administration of the common properties, the other spouse may assume sole powers of administration. These powers do not include disposition. Kahit na may kapangyarihan ka pa over your conjugal property, hindi kasali dito yung disposition or encumbrance without authority of the court or the written consent of the other spouse. Ito yung mga pagkakataong may sakit or incapacitated yung another spouse. In the absence of such authority or consent, the disposition or encumbrance shall be void. Walang bisa yan. Kung isinanla mo yan, walang pahintulot, walang bisa yan. However, the transaction shall be construed as a continuing offer on the part of the consenting spouse and the third person and may be perfected as a binding contract upon the acceptance by the other spouse or authorization by the court before the offer is withdrawn by either or both offerers. So, kunwari, incapacitated ako, may asawa ako, incapacitated siya. Ako na yung may sole powers ng administration ng aming conjugal na pag-aari. Isinanla ko yung aming ari-arian ng walang pahintulot ng asawa ko. Yun po ay void. Unless, pwedeng maging continuing offer yun at pwedeng maging pwedeng ma-ratify yun, pwedeng ma-cure yun kapag okay na yung asawa ko, hindi na siya incapacitated at iginaw niya, sige, with our consent, dalawa tayo, isang lamo yan. Yun. Magiging valid siya or pinayagan ng korte na isanla ko yung ari-arian na yun. Article 97, either spouse may dispose by will of his or her interest in the community of property. Pwede mag-execute in layman's term ng last will and testament ang kahit na sino man sa mag-asawa para kung paano niya i-dispose sa kanyang pagkamatay yung community, yung bahagi niya sa community property. Article 98, neither spouse may donate any community property without the consent of the other. However, if spouse may without the consent of the other, make moderate donations from the community property for charity or on occasions of family rejoicing or family distress. Pwede yun. Huwag lang malakihan. Pwede naman daw kumuha doon yung asawa for family gatherings, donations sa simbahan. Wala namang masama doon. Section 5. Dissolution of absolute community regime. Nagsisimula ang Section 5 sa Article 99. The absolute community terminates o nagtatapos. Number 1, upon the death of either spouse. Number 2, when there is a decree of legal separation. Number 3, when the marriage is annulled or declared void. Or number 4, in case of judicial separation of property during the marriage under Articles 134 to 138. Article 100. The separation in fact between husband and wife shall not affect the regime of absolute community except that, number 1, the spouse who lives in the conjugal home or refuses to live therein without just cause shall not have the right to be supported. Ayaw mong umuwi sa inyo, wala ka namang matibay na dahilan, wala kang karapatang suportahan. Number 2, when the consent of one spouse to any transaction to the other is required ulitin natin basahin. When the consent of one spouse to any transaction of the other is required by law, judicial authorization shall be obtained in a summary proceeding. Number 3, in the absence of sufficient community property, the separate property of both spouses shall be solidarily liable for the support of the family. The spouse present shall, upon proper petition in a summary proceeding, be given judicial authority to administer or encumber any specific separate property of the other spouse and use the fruits or proceeds thereof to satisfy the latter's share. Article 101. If a spouse without just cause abandons the other or fails to comply with his or her obligations to the family, the aggrieved spouse may petition the court for receivership, for judicial separation of property, or for authority to be the sole administrator of the absolute community, subject to such precautionary conditions as the court may impose. The obligations to the family mentioned in the preceding paragraph refer to marital, parental, or property relations. A spouse is deemed to have abandoned o pinabayaan na nila yung abandoned the other, pinabayaan niya yung kanyang asawa, when he or she has left the conjugal dwelling without intention of returning. The spouse who has left the conjugal dwelling for a period of 3 months or has failed within the same period to give any information as to his or her whereabouts shall be prima facie presumed to have no intention of returning to the conjugal dwelling. So mahalaga po pag umalis tayo, pinagbibigay alam natin kung saan tayo nagpupunta. Lalo na sa panahon ng social media at ng cellphone, nag-update tayo. Magtungo naman tayo sa section 6. Liquidation of the absolute community. Naku, ang haba pa nito. Okay. Ang haba pa nito. Liquidation of absolute community. Itutuloy na lang natin yan sa susunod na kabanata. At magtatapos tayo ngayon sa Article 101. Okay. Tatapos tayo sa Article 101 ng Family Code. Okay, at next time, babalikan natin ang Article 102 naman ng Family Code pa rin. So, sana may natutunan kayo ngayon sa aking pagbabasa. At muli na naman ako magbabasa ng batas next time at susubukan ko itong ipaliwanag at intindihin in layman's term. Good night and God bless.